exercise though, but it's a very targeted task, which is that it is going to challenge.
Gary, I have a couple questions for you. First question, are we set for tomorrow with Kevin?
Yeah, John Pullman is doing it.
Okay, and he's been in touch with Kevin?
As far as, I mean, yes, I mean, he had the information and he said he would take care of it, so.
Okay, that was question number one. Question number two, do you know if we will get a new link each week for this course, or should we keep the message from Jackie for all 5 weeks?
Well, it will be the same link. So if they know how to keep it, I would suggest keeping it.
I just keep it by putting it in my appointments file.
Yeah, I mean, there's a, you know, it depends on the computer and the software you're using. I flag it and then I can go to the flagged items and find it real fast. But there are other,
Okay.
you know, there are similar ways.
Okay,
But she's very good about if people can't find it and call her, she'll send it again.
okay. But I'd like to minimize
think-
that.
Right. And I would suggest pointing out to the group that it would be best if they know how to do it to keep it.
Okay, and a third question, is the lighting, am I okay? Can you see me all right?
Yeah, you look
Lighting,
fine.
no- Okay, fourth question, and I'm running out of questions, you'll be happy to know. Fourth question, is there some way at a later class, not this one, to show an internet, to get on the internet while we're on Zoom and show something?
Yes.
Do you know how?
Yes.
And can you teach me that? Not
Yes.
now, but sometime.
Yes.
Okay, good.
Are you talking about like a website?
Yes,
Okay.
and nothing moving, just to show something, a picture of something.
Yes.
The
That'd be-
Illinois Supreme Court website has been revised and is very, very useful now. If you want to find the Illinois Constitution or the US Constitution, they're both posted very nicely on the Illinois Supreme Court websites, along with some other stuff you might want. So it's handy. They've done a good job.
Well, it's easy to do, and you and I can do a practice run before to make sure it works right.
Yeah, that'd be good. Okay. Well, if nothing else, I can talk to you Thursday when we actually meet in person.
Right. I'm putting the finishing touches on on the class, so I'm looking forward to seeing people again.
I know, I know. I have I will have slides next time, but what I'm going to do, I think, is have Jackie send them out on Monday so people can download them and use them if they want, so we won't have to mess with them.
Okay,
I think that's easier for all of us, and particularly for anyone with vision or hearing difficulties. They only have to deal with one thing at a time.
right. How many slides do you think you're talking about?
Probably 20 to 30.
Okay. I mean, the other thing is, I could show them too while you talked. So
Yeah.
that's your call, but
I think I'll just send.
well, the only thing I'm thinking is it might be difficult for people to have those slides open. And my concern would be, I've run into several people who say, I don't have a printer. So people send this stuff.
Okay.
So you might ask today how people
Okay.
feel about it.
Okay.
But showing them is no big problem. Hi, Beth. Beth, you're muted.
How's your new dog?
Well, I think she's fine. She's still with her mom and dad. It'll be a month till I can get her. So
Oh,
I'm not sure I'm ready for what I'm getting myself into, but I've not had a puppy for many years. So
Dog training time.
yes. Oh, good. Gail got in.
Hi, Gail.
Now, I'm planning on being here for the whole 2 hours, but I have landscape people working. And in case I would seem to not be available, it's because they've come to the door to ask a question and I've stepped away for a minute. So
we might actually have to be on our own.
well, if it looks like I'm gone, it's only temporary.
Got it. Do you think most people would know about the reactions tab? What I'm thinking is there's a couple of yes or no questions I'm asking, and I might just have people do a thumbs up for yes.
I think so.
Okay, I think I'll have people try
I mean,
it.
I think we've had enough Zoom classes that people have learned how to use that function. Here comes Tedda.
Well, I noticed on the list, there are a lot of people that have had classes with me in the past, but there are some people whose names I do not recognize. So they may have had other classes or they may be new. I just don't know.
Hi, Tedda Becker.
Where is Tedda Becker?
She's right here.
She's right here.
She's got her sound turned off.
oh. Suzanne, you look just wonderful.
Well, it is unintentional. I am not doing my usual t-shirts because you wouldn't be able to see them really very well. First of all, that's the first. And secondly, I've decided I am so tired of wearing only t-shirts and shorts every day that I decided to dress a little bit better. And thirdly, I've decided in some sort of, I don't know, sympathy, empathy, solidarity with the vice president, I've been wearing pearls because,
Yay.
you know, she belongs to a sorority that uses pearls as one of their signature identifications, I guess. So she doesn't know I'm doing it, but I know I'm doing it, so I feel some little bit of sympathy with her, empathy, whatever the word might be. And other than that, I'm here.
Why do
I was
you
in your-
feel sympathy, empathy for her?
I wouldn't want to be in her shoes. Um, you know, today, any politician is going to be judged harshly, but an African, a woman and a woman of mixed race, I think is going to be judged even more harshly. I have not seen some of the criticisms because I don't visit those websites, but I'm told there's some really nasty things said about her.
Hmm.
Fortunately, I don't see that because I don't go to those websites or blogs or podcasts or whatever they are. What's the word I'm looking for? Twitter.
I agree with all you say, but she is pretty absent.
She's been absent all during
Unvisible.
this. She's been absent during this whole Afghanistan thing.
Yeah,
Possibly wisely so. I'm thinking that maybe the two of them had a little chat and said, you know, this may not go well, and why don't you just go do something for a while, and when this is over, we'll get back together so that if you do wind up running for president, you don't have to answer for this. Now, I have no basis for believing that happened. It is pure speculation on my part. But, you know, I never want to stop facts from stopping me from speculating. It may stop me from reaching conclusions, but it doesn't stop me from speculating.
I guess we're all that way. Dorsey's going to be a little late, she said at exercise this morning because her second class doesn't get out early enough.
Yeah, we're giving her a pass and letting her in late.
She doesn't even have to be admitted. We've got it set for automatic.
Ah,
They're coming in hot and heavy now.
well, while folks are coming in, I will remind you that I sent you that along with Jackie's message to you about the Zoom, there was an attachment from me. It's about 10 pages long. Most of it's an outline format, and you might want to have that handy.
Certainly doesn't look like a t-shirt.
No, I just was explaining earlier, Roland, that since we're on Zoom and no one could really see it, I've dispensed with the t-shirts. And because I was tired of wearing t-shirts, I've decided to dress a bit better. I actually had to reach toward the back of my closet to find something other than a t-shirt, since that's all I've been wearing. RJ, I have a request of you. Occasionally, I'm going to ask a yes or no question. Would you just sort of survey the chat? We don't need a count, but just a sense of, are they mainly yeses or mainly nos? Thank you. Just reminding folks as you come in that when Jackie sent you the link, she had included an attachment that was from me. It's about an 8-page outline, along with 2 other documents. If you haven't found that, you might find that now. You might want to print it out and have it handy. If you don't have a printer, you might at least want to have it handy where you can look at it periodically. It's not all that important that you look at the outline, but there are 2 things there that I will tell you about in a couple minutes that you might want to be alert to. One will be chat questions. Periodically, I'm going to ask you some chat questions.
Well, it's 9:30, Suzanne, so whenever you want.
I'm going to wait another minute, and at
okay.
9:31, we're going to start.
All right.
Despite the fact that my German nature says we should start right now, I understand that sometimes people needed to do one more thing. We'll let them do one more thing and then tune in. Again, if you just came online, a reminder that along with the email from Jackie that gave you the Zoom link, there was an attachment. That's from me. You may want that attachment as we work our way through the course this morning. All right, good morning. Welcome. Thanks for tuning in. I think almost everybody is muted, but Tetta and Beth, you might want to mute yourself, and Jane, Alan, you might want to mute yourself. I think everybody else is muted. Good morning and welcome. So the name of this course is Peeking Behind the Veil, a Civil Jury Trial. So we're going to look at a civil jury trial. And when I say peeking behind the veil, there's a lot that goes on that you don't see. And you sometimes wonder, why is this taking so long, let alone why do attorneys cost so much? And I'm hoping that by peeking behind the veil, you'll have a sense of what goes on that you don't see and why things take time and sometimes are costly. A couple warnings. First of all, obviously, this is not legal advice. Secondly, I've tried to keep everything up to date, but things change. So what I say today may not necessarily be entirely true tomorrow. If there are questions with regard to your situation, the answer obviously is see your attorney. Third caution, we're going to be talking about civil cases, not criminal. As I've said before, the amount of criminal law I know is scary. So you don't want me talking about criminal law. But even within the civil field, there are differences on different types of cases. Most civil cases are more alike than different, but family cases, probate cases involving wills, some of those areas will be different from what we've talked about here. So please understand that there are differences. And again, in case of questions, see your attorney. Not so much today, but next week, I'm going to be doing some history. And in order to make history understandable to me, I simplify it. Some of you who are history buffs will find that I'm being a bit too casual with my simplifications. Please feel free to add to it, and please feel free to look up more. I'm just trying to make it understandable both to me and to you if you're not a history buff. So the plan today is to go through this outline. So again, you should have an outline. It's about 8 pages plus 2 attachments to that outline. And it takes you from the time of a car accident through an appeal of the lawsuit. Today, we're going to focus on what happens and a little bit on how. Next week, we're going to go back through this very same outline, and we're going to ask, why do these things happen? Some of it will be history. Some of it will be political choices that we've made as a society. So we're going to go through that same outline again. Now, if you look on the outline, you're going to see that there are items in red, chat questions in red. I will try to ask most of those, not necessarily all of them today. I'm going to ask you to weigh in. Sometimes it'll be yes or no. Sometimes it'll ask you for a comment. So please find your chat button at the bottom of your screen. At least on my screen, it's at the bottom, and be ready to chat. Also there's another button there called reactions. And if you click on it, you're going to see that there's a thumbs up. So sometimes I'll just ask you yes or no. And if it's a yes, just do a thumbs up, and we'll get a sense of what people think about things as we go along. It's my effort to involve you. Those of you that have had classes with me before know that I want to have you in person. I want to see you. I want to interact with you. Can't do that. Best is hands up, thumbs up, or comments on chat. So that's days 1 and 2. Day 3 and 4, we're going to look even more behind the scenes, and we're going to look at some of the players involved in these cases and try to figure out how some of the materials that I talk about in day 1 and 2 come to be. And on day 5, I planned to, and I will still talk about alternatives to the civil litigation system. Now, in that regard, we have an opportunity. There is a movie out called Worth, W-O-R-T-H, Worth. It's on Netflix. I don't get Netflix. Those of you that know me will not be surprised to find out that I don't get Netflix, but a friend does, and I was able to watch it on Netflix. It's about 2 hours. The theme is, what is a life worth? But another theme is, what is justice? And I had planned to spend the last hour of day 5 on that question of what is justice, and do we get it through the civil litigation system? And that's why I've posed 2 quotes to you at the end of the outline. But now that I've seen the movie Worth, I'm going to suggest that you think about watching it. Worth is very factual. It takes us from the 9/11 disaster in New York and Pennsylvania and Washington, and the creation of a fund to compensate victims of 9/11. It was created by Congress with little guidance, and it was basically designed by a gentleman by the name of Ken Feinberg. It was controversial then. It's still, I think, somewhat controversial, but with the changes that he's made along the way, it's being used widely on major disasters and some not quite so major disasters. It's become part of our way of doing business, I think. The movie is raw. It's emotional. I was very glad I watched it by myself. So if you want to pass on it, feel free. But if you want to watch it between now and week 5, do so, and we might incorporate that into our last class. Now, if you don't watch it, I will still give you enough information that you will have the basic outline without having to watch it. So that brings me to the outline in front of you. Please see that periodically there are those red chat questions. I'm going to try to take most of them, but not all of them today. But notice that there's also black italic questions. Those are thought questions. Those are questions to get you thinking for next week and later weeks. Finally, I'm going to periodically stop and take questions. I have asked my colleague, RJ Robertson, who's on this course with us, to stop me if I'm starting to use jargon that's just known only to me. But but I also want to periodically stop and take your questions. Now, here's the deal. Your outline is about 8 pages long. Mine's about 30. And that's because I looked up the answers. So if you don't ask me questions, then I've looked up the answers for no good reason. The other thing that will be interesting is to see if you come up with questions that I did not think you would come up with. So please feel free as I stop periodically to ask questions. But if there's just some language I'm using that's just crazy to you, stop me or send a chat in that says, what are you talking about? And I've asked again, RJ, to stop me when I get into jargon. So we're dealing with a car accident. Those of you that know Carbondale, it happened at the corner of Glenview and 13th, right by Murdale and the park. And you will be shocked to learn that someone ran a red light at that intersection. If you've been there recently, you know that that's an everyday, if not an every hour occurrence. And somebody ran a red light and hit you. We're going to refer to you as the plaintiff. You're the good guy. You're the person that got injured. We're going to refer to the person who hit you as the defendant or the other guy. And as we get into this, you'll hear me use the word cause of action. A cause of action is a lawsuit. Why do I call it a cause of action? Because I can't get it out of my system. It's just part of my lexicon, but basically it's just a lawsuit. So with all those cautions, that's what happened. You were driving along the intersection, you got hit. Your damages both to your body, x-rays at the emergency room, some physical therapy, some medication. Luckily, you didn't get injured any more seriously than that. Cost some money, and your car was damaged. And we're going to put the damages, the out-of-pocket expenses, the medical expenses and the car expenses at $35,000. But you're not happy. You want to sue. For the next couple minutes, I want you to assume that you are very naive. You've never heard of a car accident lawsuit before in your life. You've never seen an ad on television about calling lawyers. You don't know what a personal injury lawsuit is. You're just very naive. But you've been hurt and you say, I've been hurt and you know, the other guy ought to pay. I wonder if I can sue. So you go to the US Constitution and you browse through the US Constitution. Is there anything in here that gives me the right to sue? And I can tell you that you're not going to find anything about a car accident or a lawsuit of this type or the words personal injury in the US Constitution. So you go to the Illinois Constitution. Well, until you get to the Illinois Bill of Rights and you see some general language about rights and remedies, you're still not going to find anything. And when you get to rights and remedies, you're going to think, well, there's something in here about being, if I'm wronged, I get a remedy, but I don't even know what a wrong is. So maybe there's a statute. Maybe Illinois, somewhere along the way, passed a statute. You know how they go to Springfield and they meet and they debate and they pass laws and the governor signs them and creates rights. Well, it browsed through all, however many volumes of the Illinois statutes there are, and lo and behold, nothing. Well, I still think I'm wrong, and I still want to get some recovery. How can I do that? Well, the answer is England, 1066, England, 1514. Way back, there was something that has developed called the common law, C-O-M-M-O-N, common law. Long before there was a parliament to pass any laws in England, judges were making law. It was called the common law. We're going to explore that a little more next time, as well as explore what all the alternatives there are to the common law. But judges started to realize that, hey, people have been hurt and they need some recompense. In the early days in England, it was basically about one of three things: your contracts that you made, your property, i.e. real estate, or some criminal matters. And so judges developed that law. Now you often hear people today criticize judge-made law. Who are these unelected people running around there talking about law? Well, what it amounts to is when you like the law, you call it good common law. And when you don't like the law, you call it judge-made law by unelected officials who don't know what they're doing. The reality is it comes from England and we inherited it. And it's very much a part of our law. Eventually, the common law developed tort law. Well, what's a tort? T-O-R-T. What's a tort? A tort's generally called a civil wrong. What does that mean? Well, it means somehow there was a wrong done to you, but it's not criminal. Well, you know, this guy ran the red light. That was traffic law. That's sort of criminal law. Yes, but criminal law doesn't give you recovery, and that's what you want. So tort law fills in the gap and says, if you've been harmed, then you can get a recovery under tort law. I have some friends that think that once O.J. Simpson was acquitted, he should not have been tried in civil court for a wrongful death. I have some friends who say that if there's a battery, somebody beats you up and they get arrested and tried and convicted for battery, you should not have a right to sue them. Criminal law should just be it. Well, I'm going to pause here for just a second and ask you to think about this. Think about tort law from what I've just told you, and think about criminal law. What do you think are the differences? What do you think are the differences? Why should we have both tort law and criminal law? Any thoughts from anybody? And just go into the chat. I'm not seeing any responses. Nobody? And Beth, I see your question about insurance, and we're going to hold that. Okay. Is criminal law constitutionally based? No, it's based on the common law. I'm sorry, common law is not constitutionally based. It predates constitutions. And we'll explore much more about that next week. So judges back under the age of King Henry II in the 1500s, going around England, and England, you know, does not have a written constitution. They had to resolve disputes and they created law. So it predates the Constitution, both ours and theirs. But we'll explore a little more about that next time. Well, here I think are the differences and the similarities between tort law and criminal law. When there's a crime, we want people punished and we want them deterred from doing that thing again. When there's a tort, we're not so interested in punishment, but we are interested in recompensing, giving recovery to the person who's been injured. And we want to deter people from doing that again. The penalty under a crime, if there's a financial penalty, goes to the state. The recovery under a tort law goes to you, the person who was hurt or injured. So tort law and criminal law, I think, are alike in that we're trying to deter bad conduct, but there's a difference. Under one, you get a recovery. Under the criminal law, you don't. So what do you have to have a tort? Four things. You have to have a duty. There has to be a duty. So if I walk outside my street and I'm walking along the sidewalk and I accidentally brush up against somebody, no harm, we just happen to brush up against each other, no intent, in all probability, there's no tort because there's no duty to make sure that you never, ever touch somebody. Think about being on an airplane in the middle seat. You're touching people. There's probably no duty not to harm you. Then there has to be a breach. So what does that mean? You violated that duty. Then there has to be some harm, some damage. And the cause of that harm has to be the breach. So driving a car, the law says I have a duty. I have a duty to be careful. I have a duty to watch out to other people. I have a duty to drive with care and not to harm people. Do I breach that when I speed or when I rear end somebody or when I run through a red light and cause harm? Probably. And did someone suffer? Maybe. Possibly. And if they did, is the cause of that harm my breaching my duty? Yep, then I have a tort. So those are the 4 things we have to have a tort. Are there other torts? Yeah, we'll talk about them next time. Are there other duties? And here's a question I want you to think about. Are there other duties that you think we owe each other in society? I just said that there's probably no duty to avoid harming each other accidentally as you walk down the street or as you sit next to each other on a plane. But what duties do you think are out there? And just think about that for next time. All right, so you're no longer naive. You've thought about this and you've figured out, yes, there is a cause of action and it's a tort, and the tort comes from common law. Okay, I'm going to sue. Next question. Should I get an attorney or am I going to handle this myself? So chat question. Actually, let's use the reactions button. If you think you're going to hire an attorney, would you go to the reactions button and do a thumbs up? Just do a thumbs up if you're going to hire an attorney rather than handle this yourself. And some of you are doing a thumbs up, and I am seeing a good half of you saying you're going to hire an attorney. Well, I frequently get asked the question, who's a good attorney for this cause, this matter? I'm sure RJ's been asked that question. How would I find an attorney? Next time we're going to, or maybe week 3, we're going to explore more about the attorney-client relationship. How do you find an attorney? What should you think about? Equally important, how do you fire an attorney? I've been asked that more than once. What's the relationship between an attorney and client? What is this attorney-client privilege all about? We will talk about that in week 2 or 3. Can you hire any attorney? Well, sort of. What you can't do is hire somebody who has a conflict of interest. What does that mean? That means that the other guy here is the bad guy, right? The other guy here is the defendant, the person we're going to sue. You can't hire someone who has represented the other guy in the past. Why not? Because the attorney has a conflict of interest. And you would probably be a little bit concerned about, is this attorney really on my side or on the side of the other guy? So there is a limit on whom you can hire, and we can talk a little more about that next time. Next question we have to ask. Notice we're nowhere near a courtroom yet. Next question we have to ask, did the accident occur within the statute of limitations? Well, you know what a statute of limitations is. We talk about it all the time. It's a time limit, a period during which you can file a lawsuit, and when the time limit has expired, it's too late. In Illinois, for something like the car accident, it's a 2-year statute of limitations. Okay, here's a chat question for you. What do you think are the advantages or the disadvantages of a time limit? Why should we have a time limit? So would you go to the chat and just give me some ideas as to what are your thoughts? Should there be time limits for lawsuits? Why? Why not? What are the advantages, disadvantages? I see one comment. How about some more? Okay, so several people have said something to the effect of memories fade over time. It takes too long. People don't remember things. That's true. And that's one of the reasons for a statute of limitations. But as you know, there have been many debates in recent years about extending the time limit for certain criminal matters. And while I said I wasn't going to talk about criminal, sometimes I will try to tie in current events just to help make sense of them. And as you know, there have been many efforts to extend the time limit for women who have been sexually abused or harassed early in life and didn't act on it then, weren't ready to act on it, were perhaps not even aware that it was sexual abuse or sexual harassment. And the whole issue of the priest pedophilia, Boy Scout pedophilia cases, those cases involve people later in life who come to the realization that as a child they were victimized and now they want to sue. So a number of states have extended the statute of limitations in cases like that. Well, that's a good thing to give people a chance to sue when they realize, but keep in mind what we just said, memories fade. How do you defend yourself 10 years from now, 20 years from now? So that's an interesting question. We're not going to solve it here, but I just offer it to you to think about. Is the statute of limitations the same thing for all civil matters? No. A written contract in Illinois has a 10-year statute of limitations. A tort has a 2-year statute of limitations. For children who do not have the capacity to sue, this is interesting. A child does not have the capacity to sue. A person who is legally incompetent, unable to manage his or her own affairs, cannot sue. Someone can sue on their behalf, but a child could wait until a child was 18 and then have 2 years to sue. So if a child were in this car with you and was harmed, the child could wait. Probably not going to happen. The parent is going to sue on behalf of the child. What about certain situations where you don't even know there's a harm within 2 years? And the classic case, of course, is medical. So I have surgery. Surgery is over. I'm fine. Go on about my life. 5 years later, I start having all kinds of pain. All kinds of tests are run. Eventually, they figure out, aha, there was a mistake made at the time of the surgery 5 years ago. That's why you're having the pain now. Again, the common law allows us 2 years after data discovery. So if you've discovered the sponge was left inside and that's causing the pain that you're having now, you now have 2 years. I have a story to share with you about this. You would think that this would be pretty easy. You would think that people would know when the accident happened. After all, you were there. There was a police report filed. There was an accident report filed. Insurance matters. You went to the hospital. There's all kinds of dates. You would think that this is pretty clear. Well, I had a case once where, and I was on the defense side, an individual had gotten injured twice. He was doing construction work, and he'd gotten injured twice. He filed a lawsuit that was within the statute of limitations of the second accident, except he filed it about the first accident. He was out of time on the first accident, but somehow his attorney, somebody got it confused, and he filed a lawsuit more than 2 years after the one he was talking about. He was out of luck. I don't know if his attorney got sloppy. I don't know if he got sloppy. I don't know if his attorney was trying to pull a scam and hoping we wouldn't notice. I will tell you that when it was pointed out, the attorney got very surprised. So if he was pulling a scam, he did an awfully good job of acting surprised when he realized that. That case got dismissed and was never refiled. So we have statutes of limitations. Besides that, we have once in a while the situation where we have to file some notice within a year. And that's where there's a governmental entity involved. So let's go back to our intersection at 13 and Glenview and Carbondale at Turley Park and Murdale Strip. And lo and behold, the stoplights were not working. And the city knew it. And the city didn't do anything about it. That would be an instance where the city might have some liability. And if I'm going to sue the city, I have to give it notice within a year. Or maybe it's a rural intersection and the stop sign is down. And the county knew about it and did not get it repaired. Or as I frequently see, there's been brush overgrowing, trees overgrowing, and you don't even see. Or the intersection was poorly designed to begin with. You might want to sue the state or the county or whichever governmental entity. Those require that you give a notice of a year. Why? I'm guessing because government is so huge that the right hand might not know what the left hand has done. This claim might go totally unnoticed for years. And by putting them on notice within a year, they have a chance to start gathering their data. There's one other notice that you would want to do immediately, and that, or at least your attorney wants to do immediately, and that is put the other guy's insurance company on notice. Why? Because once the insurance company knows that you have an attorney, it cannot talk to you. If I know someone has an attorney, I cannot talk to them. I have to talk to their attorney. So the attorney is going to put the insurance company for the other guy, the bad guy, the guy that hit you. And I use the word guy generically, but we all know, right, ladies, that it had to be a guy because no woman would run a red light and enter an intersection that was unsafe to do so. So we're going to keep calling it a guy. So the attorney is going to let the insurance company for the other guy know, hey, I'm in this case. Don't talk to my client, talk to me. The other reason the attorney is going to do that is something called an attorney's lien. We will talk about that later. All right. So we're within the statute of limitations. We know we've got a tort. We know it's a recognizable cause of action. We've chosen to get an attorney. Now what? Well, now we got to get ready to sue. And who are we going to sue? Well, the other guy. And in this case, you probably know who the other guy is because probably you exchanged driver's licenses at the time, or the police filed a report and you have that information. But there might be other guys out there. Think back to the days when Domino's promised you delivery within 30 minutes. Assume this is a Domino's driver who's speeding through the intersection, because if they don't, they're going to have to give you that pizza for free. And that driver is going to get fired, or at least get some kind of penalty back at the pizza place. Well, then there might be an employer that we want to get involved here. And that's called the doctrine of respondeat superior. There's a superior here, somebody above the driver who is going to respond to this lawsuit. And we're going to bring that person in. Maybe the vehicle had a recent repair work done and the brakes, but not done very well, and the brakes weren't working. And that's why he or she ran the red light. And maybe we're going to sue the repair place. Maybe the driver is known to be a very poor driver, and knowing that somebody loaned the car, that person might be liable. Was the driver impaired due to drinking? There might be a dram shop lawsuit. We'll talk about that next time. So there's all kinds of other people that we might bring into this lawsuit. Now, why? Well, some of you are thinking because lawyers are greedy and they just want to get everybody in and sue everybody and get a lot more money. And yeah, there's some truth to that, but there's some other reasons. If I don't bring those people into the lawsuit, then the other guy can point the finger at somebody who's absent, say, it wasn't my fault, it was that person's fault. Secondly, if we do bring those people in later on, now we've got to deal with conflicts of interest and new attorneys, and it gets messy. But there's another important reason. I told you that I thought there was probably $35,000 worth of damages here. That probably translates into a $100,000 lawsuit. And we'll talk about why that is probably next week. Well, let's say that the other guy had a very low insurance policy, a $50,000 insurance policy. But we think you're going to need $100,000 to recover all your damages. But he's only got $50,000. Well, if we brought in his employer or the repair shop or these other folks who might have some liability, and we'd have to make a reasonable inquiry to determine if they do, then we have more insurance money. Now, I'm going to give you 2 assignments to look into for next week. I want you to find your automobile insurance policy. I know it's in the bottom of a file somewhere, at the bottom of a drawer somewhere. Maybe if you're lucky, you can find it between now and then. I actually tried to find mine and I obviously discarded it sometime. But there are 2 things that I want you to look at. If you get your bill on paper, as I still do, then typically in that envelope, there is something called the declaration page. There is a page that you probably don't look at that says for every injury, for every accident, there's a limit to how much the insurance company will pay per person or per incident. There's bodily recovery, there's total recovery. It's a declaration page. Go find that between now and next week. And if you pay online, that information should be online for you to look at as well. The other thing, if you can find your policy, I want you to find the clause that's called subrogation, subrogation, subrogation. What you're going to find out is even if you didn't want to bring some other people into this lawsuit, your insurance company might be able to do so. And we'll talk about that more next time or the week after. So look up your insurance policy. It's a good thing to look up periodically anyway. The problem in life is when somebody hits us, we don't choose who hits us. So we can't choose if the person that hit us had a $500,000 insurance policy or that person had a $50,000 insurance policy, but it will make a difference as we'll get into as we go along here. Now, just to beat this horse a bit more, I want to talk a little bit about how difficult it can be and how much work your attorney might have to go through to figure out who to sue. So a car accident's pretty simple. The person was driving the other car or these other examples that I just talked about. Let's say that you go to the Murdale Strip and you walk into Pita Alley. And as you're walking into the Pita Alley, which is a restaurant there, you slip and fall. Who are you going to sue if you think somebody caused that accident? You think there was something on the sidewalk or the floor that caused you to slip and fall. Well, maybe if you were inside, it was the owner of Pita Alley. But maybe it was the type of flooring that they put down, and maybe it's the person that manufactured that. Or maybe it's the company that Pita Alley hires to clean the floors and what they use to clean the floor. Or maybe the reason you fell inside Pita Alley is because your shoe picked up something from outside, from the sidewalk or the parking lot. Well, who controls that? Well, I suspect Bud Slick does. They own that property. But maybe they hired somebody to clear the sidewalk or clean or remove ice from the parking lot, and that person did it negligently. You see what I'm trying to get at here is there's a lot more than, hey, I got hurt and you're the person who hurt me and I'm going to sue you. There's a lot of investigation that has to get done before anything's filed. And this is part of what's going on behind the scene that you probably don't know about, that is taking time, possibly costing money on the part of the attorney to investigate. And when we file a lawsuit, and I will get to this a bit later, when we file a lawsuit, we the attorneys say that we have made a reasonable inquiry into the facts. We don't necessarily say that they're true, that we can prove them, but we've made a reasonable inquiry into believing that they are true. And so we've got to do that. All right, so we're going to file this lawsuit. We figured out who to sue. Where are we going to file it? Because we could file it in federal court, we could file it in state court.
State.
Did I hear somebody?
State.
State court. All right. Why should we file it in state court?
Civil matter. It's a civil matter. It's an everyday deal. Federal stuff takes care of very specific things that are listed in the Constitution.
All right.
This is one of those in-between deals. And somebody's got to make a judgment, and they do it.
So let me give you a very, very brief reminder of the state of affairs in the United States after the Revolution. So it's the late 1770s, early 1780s. we have not yet adopted the US Constitution. Remember, we operated under the Articles of Confederation. We did not have a United States. We had 13 states confederated in an Article of Confederation. And the states had all the power. Who was the sovereign? It was New York, it was New Jersey, it was Pennsylvania, it was Virginia, and so on. The United States was not a sovereign, it didn't exist. Each state had all the power and they had their own courts. And then we figured out that that wasn't working too well. So we decided to revise that and we formed a United States of America in the US Constitution. But the states still retained all the power they had. The states were the sovereign, except for those powers it gave up to the federal government. And Article 3 of the US Constitution says the judicial power of the United States shall extend all cases in law and equity arising under the US Constitution or the laws of the United States, where it goes on and talks about treaties. We won't go there. So if the lawsuit arose under the Constitution, but we already said we looked at that and we didn't see anything about a personal injury lawsuit under the Constitution. Does it arise under the law of the United States? Well, there's lots of federal laws, but they don't apply to this. So we can't go to federal court. We can't go there. Ellen's instincts were correct. There is no power of the federal court to handle this case, no jurisdiction, with one exception, which we're not going to get into. So where do we go? We're going to state court. Why? Because as I just said, the state court, Illinois, just like those original 13, has all the power that a sovereign has, except those powers it gave up to the federal government. So it has all the judicial power that there would be. And it vested in 3 places, a Supreme Court, an appellate court, and a circuit court. And we have to start at a circuit court because that's what hears trial matters. Sometimes in movies, you'll hear them talk about the probate courthouse and the family courthouse and the criminal courthouse. Bigger cities in Illinois will have separate courthouses, but the court at the circuit level has jurisdiction over all matters. So you go over to Murfreesboro to Jackson County Courthouse, or you go over to Marion to Williamson County Courthouse, and all these matters could be heard there. All right, so we're in state court. Which county? I kind of like that new courthouse in Union County. It's pretty classy. If you've not been down there, it's a darn good looking courthouse. A lot more spacious than the one in Jackson County. I think I'm going to file this in Union County because it's really nice. They have really nice bathrooms, by the way, in Union County. And they have nice little rooms where attorneys and clients can meet outside the courtroom. So how about filing it over there? Can I file anywhere I want? So again, chat question for you, weigh in. Should there be a limit on what county within Illinois I can file this lawsuit, or can I file it anywhere I like? So weigh in, would you please, on the chat? File where the harm occurred, someone says. Any other thoughts? File in the county where it happened, okay? Well, you guys are pretty good at knowing what the law is. The law is this. In Illinois, I can file a lawsuit where the plaintiff resides, that's you, where the defendant resides, that's the other guy, or where the accident happened, where the cause of action arose, where the incident that gave rise to the lawsuit occurred. And it was in Jackson County, and you reside in Jackson County, and we don't know where the other guy resides because I forgot to tell you, but venue would be good in Jackson County. I have a venue story to tell you and why sometimes it makes a difference. So many years ago, I had a case in which there was a 1-car accident near Keysport, Illinois. Keysport, Illinois is a very, very small community that straddles Bond County and Clinton County. It was a dram shop case, which means people were out drinking. So this couple was out drinking. They went from one bar to another. In Keysport, yes, there are 2 or 3 bars in, or at least were 2 or 3 bars in Keysport. Get in a car, driving, and they speed, get off the road, hit a tree, they're dead. Where are we going to file it? Well, one of the taverns that they were at was in Clinton County. One of them was at Bond County. The main tavern they were at, the owner lived in one county. The location of the tavern was the other county. And where did it happen? On County Line Road, which by definition is the divider between Clinton County and Bond County. So either one was good. The plaintiff used one of those large law firms in St. Louis that you see advertised, call me, I'm your lawyer, and filed it in Bond County, which was perfectly appropriate. I wanted to move it to Clinton County. Why? Couple reasons. Bond County is the home of Greenville College, originally a Methodist college. There is a very strong Methodist influence in Bond County. For generations, Bond County was a dry county. That is, they did not have any liquor establishments in Bond County. You might think that people that are going to be on the jury in Bond County might be anti-drinking. I'm representing the tavern owner. Clinton County is very German. Germans drink. They don't see a problem with drinking. And it's a rural German farm community. Farmers don't like lawsuits. And I'm from Clinton County. My parents owned a tavern in Clinton County. A lot of people in Clinton County would know that my parents owned a tavern in Clinton County. Would I rather represent a tavern owner in a county that's known to be dry, anti-liquor, or in a county that's known to take a very liberal attitude toward drinking? So I file a motion to change venue. Had the attorney for the plaintiff come out and argued, I probably would have lost. But it's an hour drive from St. Louis to Greenville, which is the county seat of Bond County. And the attorneys didn't want to be bothered, and they didn't care where the lawsuit was filed because they were hoping to file and settle. So they called the court and said it was okay to grant my motion. We moved it to Clinton County. I left the law firm before it was tried, so I can't tell you what happened, but that was my venue story. Could have been either place, perfectly legitimate to have it in either place. Now I'm going to tell you a story where a judge violated the law on venue, but I think did so rightly. So many years ago, I used to be in Springfield, Illinois, and I remember a story that then state court judge Jean Scott told. She was one of the newest judges on the bench, so she gets assigned small claims court. And she realized that there were a lot of cases being filed by a funeral home against people who had not paid their bill for the funeral. And the funeral homes were in small towns away from Springfield. They were in other counties. They were in Hillsborough and Litchfield and Taylorville. Now imagine that you're a family of someone who's died and you can't pay the bill and now you're being sued. You're not a happy person. Now you have to go to Springfield to defend that suit. Why? Because there was a Springfield funeral home that owned all those other homes in those small towns. So the attorney for the funeral home would rather just stay in Springfield and sue everybody and make everybody come to Springfield. It was proper to file it in Springfield because the owner of the whole group of funeral homes was in Springfield. Judge Scott, however, said, it's bad enough that these people are being sued in small claims court for a bill they couldn't pay to bury their loved one. I am not making them come to Springfield. I know it's appropriate. I don't care. I'm not going to hear these cases in Springfield. Refile it in Taylorville or Hillsborough or wherever. I think she was right under justice, even though the attorney for the funeral home had the right to have it there. All right. I've been going for a while and I needed a sip of water. So we're going to take a break in about 10 minutes. But we're now going to get to drafting the complaint. So we're going to figure out we figured out now who to sue, the other guy, where to file at state court, Jackson County. We're within the time limit. So now we're going to draft it. Now, the reality is there have been so many lawsuits about car accidents filed in Illinois or any other state that it's not hard to figure out how to draft a lawsuit on that. But let's assume again, let's just be very naive and assume that there are very few. What would we do? Well, if we're a good attorney, we would research the law. What's the law on tort? What's the law about duty and breach and causation and damages? And what words do I have to put in the complaint? And what can't I put in the complaint? But because there's only about 10,000 lawsuits of this nature filed in Illinois in any given year, I'm making up that number 10,000, but I'm sure that I'm correct. We could go to a form book, or we could go to jury instructions. And next time I'll talk more about how jury instructions get written. But let's take a look at our complaint. So I believe it is page 8 or 9. It's page 10. Sorry, it's page 10. So if you look at your handout on page 10, you see that you, the plaintiff, that's your name, you, are suing other guy, the defendant, in the Circuit Court of the First Circuit, Jackson County, State of Illinois. So we're telling everybody that we're filing this in the state court. We're filing it in the First Circuit because that's a geographic division of the courts of Illinois. We're in the First Circuit, and we're filing it in Jackson County. 21L. 21 means we filed it in the year 2021. L means it's a law matter. I'll explain that in a minute. And then the line means the clerk's going to fill in the number. So if this is the 225th case filed in the law court in Jackson County in the year 2021, the clerk is going to write that number in. If it's the 10th case, going to write that number in. Our pleading is entitled a complaint, so no one can be confused. We're going to make a jury demand, though we're going to come back and talk about that in a minute. And while this is very simple and most attorneys would fancy this up a lot, I think we've got most of the elements here. So we're saying you, a resident of Jackson County, that's telling the court that you have jurisdiction over you, the plaintiff, and venue. On August 1, 2021, that's telling us we're within the statute of limitations. Had possession and control of a car driving west on Main Street in Carbondale, Jackson County. Again, that's telling us venue's good. Other guy whose address I did not give, I should have. On the same date, had possession and control of a car driving south on Glenview in Jackson County. On that date, defendant owed a duty of care to plaintiff. How do I know that? Because I've researched the law, and I know that when you start driving a vehicle, you owe a duty of care to the people on the road. Paragraph 4, notwithstanding defendant's duty to plaintiff, defendant negligently operated his vehicle, collided with the vehicle driven by plaintiff, failed to keep a proper lookout, failed to operate the vehicle in order to avoid a collision, entered an intersection when it was not safe to do so, and failed to stop at the red light. So he breached the duty, did all those things. I've got 4 of them listed. One would be enough, but I'm listing 4 because what if the jury doesn't believe one of them? I'm going to try to get as many breaches in as possible. Paragraph 5, as a result of the breach, defendant caused injury. So notice I've got duty, I've got a breach of the duty, I've got a cause of injury, and I'm showing damages. Notice that I don't have in a figure like $10 million. That's because under Illinois law, on a tort action, I'm not allowed to list a financial amount. I can list the type of injuries, medical expenses and loss of income, and damage to the vehicle, but I'm not allowed to say $10 million. Why not? Well, your neighbors pick up the newspaper and read other guys' neighbors rather, pick up the newspaper and read other guys been sued for $10 million, they might look aghast or askance at the other guy. Other guys working in town, the employer might think, oh my gosh, $10 million. What if he tries stealing from me to come up with that $10 million? What if this is a nursing home or a hospital or a doctor, and you're saying this person's been sued for $10 million? People might stop using that nursing home or going to that doctor. So Illinois has said, you list the type of injuries, but you don't give it a financial figure, except for one thing. And here's where I made a mistake. Might not be my only mistake, but this I know is a mistake. So my wherefore clause, wherefore plaintiff prays, for judgment in excess of 15,000. I should have said 50. So plaintiff prays for judgment in excess of $50,000 plus cost. Why that amount? Because matters under 50,000 in Jackson County go to one type of judge, and matters over 50,000 in Jackson County go to a different type of judge. That's all it is. We have L matters and we have LM. L is big law, if you will. LM is little law, big and little referring to the amount of money, not to the importance of the case. And then I would sign it. Notice that the plaintiff is not going to sign. I'm going to sign. And I'm going to include my address and bar number. What's the significance of my signature? When I sign a complaint, I am saying to the court that I have made a reasonable inquiry into the facts. Not that I know every one of them is provable, not that I know every one of them is absolutely true, but I've made a reasonable inquiry, and I believe that I can prove them and that they're going to be found true. And I've made a reasonable inquiry into what the law is. And I'm not making up the law. I'm not changing the law. I'm not creating something that has been thrown out of court. Now, that poses two problems. What if I do want to change the law? Well, then I need to be upfront with the court and say that. The other problem it poses is, what if your client lied to you? And that's why you have to make a reasonable inquiry before you file something. Now, I'm going to try to keep us as limited as possible to going off track here, but here's another example where we're dealing with something in the news that I will take a moment or a couple moments to talk about. You know from the news that there have been at least two instances where attorneys involved in some of the voting cases from the 2020 election have been charged with attorney's fees. They have been sanctioned in some way because of the lawsuits they filed. There were two attorneys in Colorado that had nothing to do with Trump, as far as I know. They simply decided to file their own lawsuit, and they have been made to pay attorney's fees in Colorado. There are some of the attorneys that you see on television that are associated with Trump, Sidney Powell and some others, who in Michigan are being ordered to pay attorney's fees. While I will not go through all of the various rules and laws in federal court, both of those cases were in federal court, but it's the same principle that I'm talking about, which is if you did not make that reasonable inquiry, you can be made to pay attorney's fees for the other side, and you can be sanctioned in other ways. Now, I'm going to leave you with a question to think about for a minute, and I'm going to take a 5-minute break because I have to get a cough drop and some water. Here's my question. So while we're drafting this complaint, it would be good to know the burden of proof. Am I going to have to prove to a reasonable, am I going to have to prove beyond a reasonable doubt? Or am I going to have to prove to some lesser burden? And the burden in civil court is normally a preponderance of the evidence. What does that mean? It means that when you look at all the evidence, not itemizing it, but looking at all of it as a whole, is the preponderance of the evidence, sometimes said to be 50 degrees, 50% plus, just a little more, that this is more likely true than not. So if I bring all my evidence in front of you and you look at it and you say, boy, it's 50-50, it could go either way, I just don't know, I lose. But if I bring all my evidence in front of you and you look at it and you say, boy, it's close, but it tilts just a little bit in favor of the plaintiff, then I win. Is it more likely than not that what I've shown you is going to be proven true? So there is a stricter burden of proof on criminal cases than on civil cases. I'm going to take a 5-minute break. I'm going to give you a 5-minute break, and I'm going to ask you to think about and weigh in on, should there be a stricter burden of proof in criminal court than state court? And go ahead and take a look at that while I take a 5-minute break. The screen will stay up, everything will be the same, and we will return in just 5 minutes. as we're returning, and I'll start in just a few more seconds, but I'm going to be checking the chat for answers to that question, but I'm also going to ask you if there are any other questions that I have not answered. So if there's any question that I have not answered yet that you think I should have, feel free to put it into chat. And it looks like on the burden of proof question, you all think that it should be less of a burden on a civil matter, a higher burden on a criminal matter. And obviously when somebody's life is at stake, their freedoms at stake probably is a good idea. Somebody asked me about punitive damages, and that is the next topic. But before I go there, RJ, is there anything that I should have clarified that I have not yet clarified?
No, I don't think so. I think things have been pretty clear. I've been looking at the chat questions, and I don't think people are confused by any specific thing that you said.
Okay. Well, let's talk about punitive damages. So I did not ask for punitive damages. And there's a very good reason I did not ask for them. In Illinois, I cannot ask for punitive damages unless and until I have a hearing in front of a judge who gives me the right to ask for punitive damages. So, and furthermore, there are certain kinds of categories of cases in Illinois where I could not ask for punitive damages because the legislature has said I could not. You probably remember the McDonald's case. You may not remember the facts of the McDonald's case, so I included them. The jury decided in the McDonald's case that the woman was entitled to $200,000, but they also decided that she was partly liable. So that reduced the amount of her compensation to $160,000. These were burns that she suffered from the coffee. But the part of the case that got a lot of attention is that the jury awarded $2.7 million in punitive damages. And that got a lot of attention and people thought that was outrageous. Well, $2.7 million at the time of the case was filed was 2 days worth of revenue from McDonald's coffee sales. Keep in mind that at that time, the woman who was injured put on evidence that McDonald's knew their coffee was hot. They knew that at the moment it is poured out of the machine and into the cup, it is dangerously hot. They also believed that served at that temperature, it was the tastiest. They had no warnings, assuming warnings were even needed, that coffee is hot. And the jury thought that McDonald's, they had had complaints over the years that coffee, people had been burned and they had ignored them. So the jury thought, as they sometimes do, that McDonald's was more than negligent. They were reckless, and they decided to award punitive damages. The judge reduced that award of $2.7 million to $480,000. Now, the case is often criticized because it was so high. The Supreme Court has been asked to weigh in on some other cases. The US Supreme Court, and this is the one time that you could get from state court to federal court, is because you can raise a constitutional issue. And in other cases, companies have raised the constitutional issue that their property is being taken without due process with regard to these punitive damage awards. And they have asked the US Supreme Court to set some kind of standard as to when and how much you could get for punitive damages. The last I looked, there's not real clear guidance, but there's real strong hints from the US Supreme Court that there should be some connection between the amount of compensatory damages, that's the damages you're wanting here to compensate you for your injuries, and that amount and the amount of punitive damages. And there's been some suggestion from the court, not a rule, but some hints that maybe it's a single digit multiplier. So maybe if the damages to this lady was $200,000, then maybe 5 times that, 1 million would be appropriate. This is an ongoing debate. Stay tuned. But the bottom line is we can't get it. The reason in Illinois that you would have to have a hearing to determine whether or not you can seek punitive damages before you can even put it in your complaint is this. Once I seek punitive damages, I'm allowed to look at your financials. So if the only thing I want is to compensate me, then the jury's going to find out about my injury. How much have I suffered financially? And how much have I suffered emotionally and with pain and suffering? Your financial situation, if you're the other guy, doesn't even come into play. But if I sue you for punitive damages, the whole idea we're going to punish you now, we've moved beyond that original distinction between torts and criminal law of punishment. Now we've got punishment in the picture. If I'm going to punish you, then I need to know how much you're worth, because $10,000 against you might be a lot of money, but against Ford Motor Company, it's nickels and dimes. So I'm allowed to put on evidence as to your financial standing. Well, that's pretty dangerous stuff. And we're not going to let people do that to possible defendants if there's not been some kind of a hearing to show that it's likely that they're going to be able to prove punitive damages. So long story short, they are more rare than you think they are if you just read the headlines. Now, somebody had a question about do they look at the financials of the plaintiff? No, because you're not punishing the plaintiff. And I'll talk probably next week about the one time when that would make a difference. You know, the plaintiff's financial worth would make a difference, but not now. Somebody asked me, is the burden of proof the same in all states? No. Well, let me revise that and say sometimes. Generally, most states use a civil standard of preponderance of the evidence. Most states use, in fact, I think all states use a criminal standard of beyond a reasonable doubt. There are some states in some matters that use a standard called clear and convincing. Now, just in case it's hard to understand the difference between a reasonable, beyond a reasonable doubt and a preponderance of the evidence, we really make it confusing by throwing in this language, clear and convincing. It's somewhat higher. It's very confusing. Let's not go there any further, but yes, all states basically use the civil standard, the same civil standard and the same criminal standard most of the time. There are some matters in which some states use a third standard, clear and convincing. There was another question that I wanted to answer. So let me just back up and make sure that I'm clear. Compensatory damages are the ones that you suffered here. The damage to your car, the damage to your body, both financially, emotionally, pain and suffering. Punitive damages are designed to punish the other side for what they've done. Somebody asked me if the brakes were bad on Ford, would you sue Ford in federal court? Probably not, because there's probably no basis for getting them to federal court, but that would get me into a lot of weeds I'd rather not get into right now. We might visit that next time. Okay, RJ, anything else I should say about punitive damages? Okay, all right. So do we want a jury? Notice on my complaint, I asked for a jury demand. How many of you, let's just use the thumbs up again. How many of you would ask for a jury rather than a judge to try this case? So yes, thumbs up if you would use a jury. Okay. How many of you, why don't you erase those? How many of you would use a judge only to try this case? Couple, so a couple of you, okay. Well, if you don't make a jury demand now and pay the jury fee, you're out of luck. So the plaintiff goes first. The plaintiff made a jury demand in the original filing and paid the jury demand. You're going to a jury. Let's say the plaintiff did not. You're the plaintiff again. You're the one that got hurt. You did not make a jury request. The defendant can do so and pay the fee. If you don't pay the fee, you lose. I used to answer, and I would always file a jury demand in my answer, because even if the plaintiff had made a jury demand, the plaintiff could change his or her mind, and I wanted a jury, so I would always file a jury demand. I got to tell you the number of times that I would wake up at 3 o'clock in the morning and say, that answer I filed yesterday, did I make a jury demand? And once you wake up at 3 o'clock in the morning and you can't remember if you made a jury demand, you might as well get out of bed, get dressed, go to the office and look it up, because you're not going back to sleep. Luckily, I had a very good attorney, very good secretary, who would not let that matter out of the courtroom, out of my office without a jury demand being there. In Illinois, you get a jury of 12 for a civil matter or a criminal matter. At one time, Illinois tried to make it a 6 jurors for a civil matter, and the court has struck that down and said you're entitled to 12. If we were in federal court on a civil matter, we would probably almost certainly be using a jury of 6. Let me briefly tell you a story of selecting a jury, or why it matters how you select a jury. As you know, and I'm going to jump ahead a little bit, but this is a good time to do this. People are called to the courthouse to be jurors. Excuse me, I thought I've set this off, and apparently I have not. I think I've done it now. People are called to the courthouse to be jurors. They're assigned a number. They may or may not fill out a survey. They may have filled out a survey before they got there. They may fill it out when they get there. There may be no survey at all. They're called to the courtroom, and the judge asks them some questions. And when the judge finishes, the attorneys get to ask some questions. We call that voir dire, V-O-I-R-D-I-R-E, voir dire. It's French. It means to seek the truth. I told you earlier that our common law system comes from England. So what's with this French stuff? I have no idea is the short answer. I don't know why we call it voir dire and use a French term as opposed to an English term. We just do. But it means to speak the truth. We're asking the jurors to speak the truth, even though in the end, it's the witnesses that are going to speak the truth as well. Well, jury selection is a challenge. And if you watch, I think it's called Bull, the television show, he's supposedly an expert on jury selection. I was involved in one case where there was one side, not my side, had brought in a jury expert. Generally, we use our gut. I was involved in a case as a mediator, and I'll talk about that later. But this was a case where a woman had been injured. And the dispute was really not whether or not she'd been injured, but how badly she was injured. She had been treated and she claimed to have ongoing pain. But the defense said, look, she said no further medical treatment, so her pain can't be that bad. Well, her situation was this: she did not have health insurance. And this is pre-Obamacare. She had called up a place that did helped people who had accidents and needed further treatment, and sought further treatment, and they said, no, you don't have insurance, we're not going to see you. Now, my thought was this: if the jury turns out to be a lot of people who are unemployed, underemployed, don't have good health insurance, they may empathize with her and they may realize, yeah, she's still in pain, she's still suffering. The only reason she's not getting medical treatment is because she doesn't have health insurance. Even though those words health insurance would not be used, they would get the message. On the other hand, if the jury is made up of people that have health insurance, they might very well accept the defense argument that she must not be in that much pain and suffering because she's not been back to see a doctor. So selecting the jury makes a difference. All right, so we chose a jury to use a jury. We're not going to file our complaint. It used to be that you would go to the courthouse, not anymore. State court, you file it electronically. Federal court, you file it electronically. You pay a fee. Right now in Jackson County, the fee is about $300 if you're the plaintiff. If you're the defendant, it's about $100. Those can be waived if you can show a certain level of poverty. You're going to get assigned a judge, and you have the right to change judge one time. I'm going to postpone that discussion for next week. Sooner or later, the other guy is going to respond to that lawsuit and might file a motion to dismiss, might ask the court, throw this case out right now. We should not even have to go any further. No more time or expense on this lawsuit. Why? Well, maybe because the statute of limitation has run, which I mentioned earlier, and it's too late. Maybe because it's a minor who doesn't even have the capacity to sue. Maybe because they've created some mythical lawsuit that's not recognized in the law. Throw it out now, save us all time and money. Maybe there's certain language in that lawsuit. So maybe instead of saying other guy, a driver did this, we say other guy, a known philanderer, a known scumbag who beats his wife and hates his kids, was driving. Well, we're going to get that language stricken because that's just scandalous language that does not relate to the matter. There may be some motions of that sort. There may be some amendments to the lawsuit filed back and forth. Eventually, the defendant is going to file an answer. And if the defendant admits certain things, then the plaintiff doesn't have to prove that at trial. If the defendant denies everything, then everything has to get proven at trial. So now we're going to move to the discovery phase. Now, most of you, I suspect, have watched Perry Mason at one point in your life. And you know that in Perry Mason, there was always that moment where Perry would get the witness to say something that was a total surprise to everybody and totally turned the case around. There were always those Perry Mason moments. Well, in modern day litigation, we have tried to get rid of those Perry Mason moments. We tried to get rid of discovery of surprises, and we do so by having what we call discovery. We have various things that can be done during this pre-trial stage to discover the facts, issues, anything related to the lawsuit. So you, again, are the plaintiff. You're the person that got injured. You're going to send the defense attorney, the other guy's attorney, state a question that says, do you know any witnesses? Tell me who they are and where they live. You're going to request that the other side produced certain documents. Did you take any photos? We want to see them. Do you have any reports that we haven't seen yet? We want to see them. And the defense attorney, the other guy's attorney, is going to do the same for you. Today, the court requires that those sorts of things be done automatically. You don't even have to ask for that. And that's done to speed things up. Then there could be depositions. Now, a deposition is a series of questions asked under oath before a stenographer. Typically, in my day, it was done in person. Right now, a lot of these are being done through Zoom or other Zoom-like processes. They could be done by telephone. But the person who's being deposed is under oath and must tell the truth, and everything is written down by or recorded by the stenographer. In a case like this, there's going to be a deposition taken of the plaintiff, you, because the defense wants to know how you think the accident happened and how you were harmed. There's going to be a deposition that your attorney is going to take of the other guy. Why? How do you think the accident happened? Do you have any excuse as to why you injured the plaintiff? Do you know of anybody else who's a witness? And then there might be some witnesses' depositions taken. Now, why would you take the deposition of a witness? I mentioned before to you that if I know you're represented by an attorney, I can't talk to you. I have to talk to your attorney. Well, there are witnesses out there that probably aren't represented by attorneys. So the attorneys or their investigators could go out and interview them. They don't have to take a deposition. But here's the problem. I go out and I interview and I see Harriet Simon. So I go out and I interview Harriet Simon, and she does not have an attorney. And she tells me what happened. And then when we get to trial, she changes what she says. Well, how do I show that one story or another is not the truth? That she told me one thing and now on the stand she's telling another. Well, if I had her under oath and I had it recorded, I'd have a proof of her prior statement. And I could say to the jury, look, she's changing her story. Do you really want to believe her? So there's a value in having this recorded as a deposition. Another value of having it recorded as a deposition, and another value of depositions, is I start to narrow the areas that are going to be presented to a jury. The more people agree, the less we're going to have to make proof. And another purpose of a deposition is I assess the credibility of a witness. What do I mean by that? Well, especially when I can see them in person, but even now with Zoom, I start to get a sense of how's this person going to come across at trial? Is the jury going to believe this person? Or is this person going to be somebody that just waffles around, never answers a question, argues with the attorneys, and does not make a good impression? There are some times where I will seek an independent medical exam. So let's say that the other guy's attorney understands that you've been injured, but doesn't think you were injured as badly as you think you were. They might ask you to go to see a doctor of their choice and be examined. Not a complete physical, examine obviously those parts of your body that are at issue. So if you claimed you broke a leg, you'd go to an orthopedist. That is a way to get another view of how serious are the injuries. One thing we can't do is lie detectors. The legislature has said you can't use lie detectors as part of the discovery to see if people are telling the truth. So we go through this whole process. We're done with it. We have a pretty good idea as to what the matter looks like. We have a pretty good idea as to how it's going to appear to a jury. At this point, several things are going to happen. One side or another is going to file what we call a dispositive motion. Judge, dispose of this case right now without any further going to trial, We've done all this work. We have a pretty good idea as to what happened. Here it is. There's not going to be any real dispute about the facts. Rule, throw this case out. Give me summary judgment. Give me a judgment in a summary fashion without me having to prove anything else except these written testimony that I presented to you from the depositions. Either side can file that. If there's any dispute about facts, it's going to go to trial. If there's any doubt as to what the truth is, it's going to go to trial. The next thing that's going to happen, if there wasn't, and there may not be dispositive motions filed, but next is going to be a settlement conference. So in Illinois, as I think in most jurisdictions, there's a rule that requires the court to hold a pre-trial settlement conference. And the judge is primarily going to use that as a chance to narrow down the issues and to try to get the parties to settle. The judge might try to get the parties to settle himself or herself, or the judge might refer the matter to mediation. I used to do mediations. I used to sit between the parties and listen to them and try to help them evaluate the case and come to a reasonable solution. As we get nearer the trial, we're going to have what are called motions in limine. That's a Latin word. Motions in limine, I-N-L-I-M-I-N-E. In limine means threshold, the door. So these are motions being filed on the threshold or the door of the trial. And the attorneys are asking the judge to make rulings in advance that certain things can't come in. For example, you can't bring in the fact that the guy who hit you is a philanderer or beats his wife or doesn't pay his bills or is a scumbag. None of that is relevant to the fact that as to whether or not he hit you. You can't bring in insurance, and we'll talk more about that next week. You can't bring in the fact that medical bills have already been paid by insurance, so why should they be presented to the jury? We'll talk about that next week. And if there's going to be exhibits, they might be prepared right then and there. So finally, let's see, after an hour and a half, we're at trial. So we've been peeking behind the veil of all this work that goes on before we ever get to trial. Now, I asked you before if you thought we should have a jury or not, and a lot of you said yes. I talked a little bit about jury selection. Let me ask you this question. Why do we go through jury selection? Why don't we just take the first 12 people that come through the door, or at least ask the first handful of people, do you know these parties? Do you know anything about them? Do you know, do you have any stock in ownership of the companies? Do you know the attorneys? And if the answer is no, take 12 people. Why do we go through voir dire? So why don't you tell me, any thoughts about why we should question the jury? And somebody says to ensure the fairest, most objective, okay. Anybody else? To discover biases, to make sure that there's no advantage to either side. Okay, good. I will tell you one story about jury selection. I was in federal court, 6 jurors in federal court on a civil matter. The case was involving political discrimination. So this individual claimed that he had been discriminated against at work, and the reason he was discriminated against at work is because he was a Democrat and the Republicans were in control. Well, we were selecting the jury. The area that he worked in was medical. So this was a state facility involving medicine, like a nursing home or a residence facility of some sort. How this guy got in the medical field, I don't know. He was not a doctor. He was not a nurse. But he had supervisory control over nurses for certain matters. As we were selecting the jury, in those first 6, there was a woman who's a nurse. And it's interesting, people will tell you, you don't want a nurse because they're too sympathetic, and other people will tell you, no, you want a nurse because they've heard all the stories and they know when people are exaggerating. Well, in this case, the nurse who comes into the jury pool looks like the chief nurse I'm going to put on the stand to talk about what a jerk this guy was. Because our defense was not that we didn't do these bad things to him, because we did these bad things to him. Our defense was he's a jerk. He's incompetent. We did bad things to him because he was incompetent. He did not do his job well, and he did not treat people well. And so they kept taking duties away from him. So when I noticed that this nurse looked a whole lot like, physically, you could almost think she was a sister to the main nurse I was going to put on the stand, I took her. And I did win that jury. So whether or not that was a good move, I don't know. Now, what I'm going to do, because we are on the eve of trying this case and putting on evidence, and we are running out of time, and I see a lot of questions, what I'm going to do is take time and go back and answer some questions, and then we will break for the day, and we will start this case on next week at trial. So how much is the jury fee? Is it covered by the state if you use a public defender? The jury fee, as I said before, would be included in the fees that filed. So if you're the plaintiff, your fee in Jackson County, and it varies by county, but in Jackson County, it's $300. If you're the other guy, you're the defendant, it's about $120, I think. And the jury fee is part of that. If this were a criminal case and you were using a public defender, yes, I think it would be covered by the state. But again, I'm not a criminal attorney, and you really don't want to trust my knowledge of criminal law. Are jury trials happening now in Jackson County or not due to COVID? They are happening. There have been 2 civil jury trials that I know of in the last few months. They have done a lot of work with putting in plastic shields between the witness stand and the rest of the courtroom, and separating the juries, and getting people microphones so they could be heard despite the distances that have been imposed. So yes, they are back in business for jury trials in Jackson County. RJ came to my help in answering that French language was the official language of the royal courts after the Norman invasion first. All right, so thank you, RJ, and let's pick that up next time. So Norman invasion of England, 1066, we'll pick that up next time. Thank you for that. Do defendants have the right to represent themselves? Yes, they do. Anybody can go to court and represent himself or herself. You, of course, know the story that as to how good a choice that is, but you can. Mediation, let me talk about that probably in 2 sessions from now. Could you show patterns of poor driving? Now that's an interesting question. So I said, you can't bring up the fact that the defendant's a scumbag, or the defendant beats his wife or her husband. You can't, fails to pay child support. You can't bring those things up. Could you show a pattern of poor driving? I think not. I think in this case, no. I could imagine a case where you could, but in this case, all we want the jury to focus on is not, are you a bad driver? Not, are you a bad person? But in this instance, at this time, did you fail to drive with care? So we don't want the jury getting confused. There were a couple other questions I wanted to answer. If you were the defendant, why would you prefer the jury trial rather than a judicial trial? You know, one thing I think I will talk about probably in week 3 is there are some courthouses that are known to be pro-plaintiff or pro-defendant for a whole bunch of reasons that I can get into that have nothing to do with the law, but a lot to do with the culture. I mentioned before that one of the reasons to have the case tried, the case involving the car accident after they were drinking, to have that tried in Clinton County. One reason is Clinton County is full of farmers. Farmers tend to be pretty independent people. They think that they take care of themselves. They don't rely on government assistance. They're not real crazy about things like paying people money for any reason other than they earned it. So a county like that is probably going to be a pro-defense county in a case like that dram shop case. They're not going to want to give out money too readily. In that case, I might want a jury. Other counties are known as being pro-plaintiff, particularly if they're an industrial county with a lot of unions where people get hurt at work, and people know that when you get hurt at work, you have a lot of injuries and you can't go back to work and make the same amount of money, and they tend to be pretty favorable toward plaintiffs. In that case, if I were the plaintiff here, I'd want that case tried by a jury. If I were the defendant, I might want that case tried by a defendant, by a judge. So there's lots of reasons. Sometimes people just have different personal feelings toward judges or juries that have nothing to do with the law, and that might come into play, but I've tried to give you the more common reasons. All right, we are at the point where we're going to try this case, but we are very close to being out of time, and I know that we're not going to get very far, but let's see if we can at least get started. So let's answer my question, or did we answer my, I guess we did. One thing I want to tell you about jury selection. I've told you that you really don't want me to talk about criminal law, but again, I try to tie in some of the current events in the country to help you understand. And here's one of them. In criminal matters, there has been an effort in some counties by some states' attorneys or district attorneys, prosecutors, to throw out blacks and to have an all-white jury, particularly where the victim was white and the defendant is black. The US Supreme Court has intervened and told you can't do that. So now if it's a criminal matter, one thing that the prosecutor has to be ready to do is to show why he or she threw out jurors who were minority, typically black, but in certain parts of the country, it might be Native Americans or it might be Hispanics. Probably doesn't come up so much in civil cases, but it could. And back to my question about taking the first 12. The judge, as you know, is going to ask some questions of the jury, and then the attorneys are going to ask some questions. And if the jurors, potential jurors say, yeah, I know that person, or, you know, I hate giving away money to people, so I don't care what they show, I'm not going to give any recovery. Those are going to be reasons to strike somebody for cause. So thank you, Mr. Juror, Ms. Juror. We appreciate your coming, but you're now excused. You can go home. Then, however, the attorneys have the right to strike people for no reason at all, peremptory strikes. And that's what often comes up in those criminal matters where prosecutors sometimes exclude blacks from the jury for no reason at all, other than we think because they're black. Well, in a case like this, both sides, both attorneys would question the jury and then would have a right to say, I'm excused juror so-and-so. Arizona just passed a new rule. You can't do that anymore. Arizona has just passed a new rule that the only reason a juror could be excused is for cause. So the juror knows the parties, knows the attorneys, owns stock in the company, has some attitude toward the system where he or she can't be independent and follow the law. Those would be the only reason somebody would be excused. So that's something new. I think I'm going to give you some questions to think about for next time, and we will bring this to a close. So let's say we're in trial. And let's say we want to bring in a witness who happened to be at the scene. Maybe it was 2 or 3 cars behind and saw the accident. Can that person testify? What if somebody, very nice person, got out of his or her car and started taking photos of the scene and taking photos of the vehicles after the accident? Can those photos come into evidence? What about your car? Because typically what you're going to do is you're going to have taken the car to a body shop and you're going to get an estimate. Can you bring that estimate into trial and say, see, it's going to cost $7,000 to repair my car? Can that estimate come into trial? What about the police report? Because in all probability, the police were called and the police came and they asked both sides, the person who got injured, the person who did who ran the red light, what happened? And maybe they asked some other witnesses what happened and they write it up in some nice little form. Can you bring in that police report? We all know that what happens in these cases is people call their insurance companies and then their insurance companies send out adjusters either to meet with you or more likely to talk with you by phone. Can their notes come into trial? What about the defendant's statement? So the defendant ran this red light, got a ticket. What if the defendant simply sends the ticket in, marks it guilty, sends in a fine? Can that come into trial in the civil case for you, for the injuries? And what if, on the other hand, the defendant pled not guilty, went to trial, and was convicted of running a red light? Can that come in? I'm going to leave you with those questions to think about for next week. I am going to see last minute questions that I'm going to take up as I leave you with those questions to think about. Am I saying that judges are not impartial? I am saying that jurors are part of their culture and that sometimes jurors have certain attitudes. Like I was saying before, jurors come from an industrial area where people get hurt at work and they're protective of union members, or jurors come from a farm area where they just don't like to give away money. Beyond that, are some judges impartial? Some judges have a reputation of being more pro-plaintiff, more pro-defendant. That's one of the reasons you get a chance to take a change of judge. Somebody says that the last time he or she was on jury duty, only the judge asked questions. That's one of those things that I think judges control. In federal court, the judges do not like the lawyers, to ask questions, because the lawyers are trying to persuade the jurors, the potential jurors from the very beginning about their case. So federal court, judges do not like the attorneys to ask questions at all and keep it pretty well under control of the jury. Plus it goes the judge. Plus it goes a lot faster. How many jury candidates can a lawyer strike? You know, I knew that until you asked, so I will find that out for next week. I used to know that, but I forgot. Speaking of which, how do I know all this stuff? Well, I'm going to show you a book. This book is 860 pages. Looks pretty thick. This book contains, for Illinois rules of procedure. So there are court procedures. There are statutes that govern how we do court. And there are rules of evidence. They are all in here, 860 pages worth. There's some other stuff in here that I would not need. But if I were back in the days when I went to trial, I took this book with me and I put it on the table in front of me. And it was a subtle signal to the judge that, hey, maybe I don't know all the rules, but I've got them handy just in case I need to look them up. It was also handy in case I did need to look something up. I had it right in front of me. Today, all of these are online, and I might not have to take it in, but I still think there was a value in physically having that book right in front of me, saying to the judge, I'm prepared. I've checked into these things. Now, that brings me to a couple questions for you for next time. Next time, I'm going to have some slides. I would like to send them to you in advance and not use them during the lecture. I would prefer that you print them out and look at them at your leisure, but I know some of you don't have printers, and some of you may prefer not to do that. Some of you may prefer that I show the slide in what we call a share screen, so you would see both me in miniature and you would see the slide. I would like to know from you which you prefer. So if you could weigh in on the chat and tell me, I prefer the getting them in advance and I'll print them out, or I would prefer that you show them during the lecture. So would you weigh in, please? Here's an interesting question. If we had socialized medicine, do I think there would be fewer personal injury lawsuits because people would have their medical bills paid and it would not be an issue? Well, I don't know of any statistical evidence one way or another on that. I do not know of any empirical work on that. I do know that if I'm the parent of a child at a playground and I don't have health insurance, again, this is pre-Obama days, pre-Obamacare days, and my kid gets injured on the playground and I take my kid to the ER and I have some ER bills, I'm looking for somebody to pay for them. I don't know. There are other people who look for the jackpot. They want that mythical pot of gold and they're going to find it. So I don't know is the answer to the question. And I don't know of any research that tells us one way or another. Now, one person has said I can do either one. I'm not hearing from anybody else. Somebody else prefers that I share. Okay. Well, okay. So a couple of people are saying they don't want them in advance. They prefer that I use them during the lecture. So I will work with Gary to figure out the best way to do that so that you can still see me. I know some people have some vision issues. Some people have some hearing issues that one or another makes different. And then some of us have technological issues that makes a difference. Okay, one last housekeeping matter before we close off for the day. And that is to repeat what I said earlier. We're going to use this outline again next week, obviously because we didn't finish it today, but also because then we're going to go through it a second time and do more theoretical discussions. So please keep this outline. I think that Jackie is going to send you a Zoom link every week, but I'm not sure of that. So I strongly suggest that you take the Zoom link from this week and keep it somewhere so you can use it again next week, because the Zoom link, I'm told, should be the same. So whatever it is that you do to keep today's message or yesterday's message from Jackie Welsh handy for next week, please do that. And that way she doesn't have to resend it. Third and final reminder, and that is, I mentioned earlier, the film Worth, W-O-R-T-H, Worth. It is out on Netflix. It is a story of the Victims' Compensation Fund that was set up after 9/11. It is an alternative to litigation. I'm pretty familiar with that Victims' Compensation Fund, and this film is pretty true to the facts as I know them. The people in the film, for the most part, are composites. So rather than show you all 6,000 people that they dealt with, they're showing you a handful of the people who sort of represent the group. The two main characters in the film, however, are real people. The actors are not the people who are not the real people. The actors are portraying people who were real. Ken Feinberg and his assistant, Camille, somebody whose last name I'm now forgetting. It's a difficult movie to watch, I think. It's pretty raw, emotional, but it is pretty good. So if you are interested, you might take a look at that before the 5th class. Regardless, during the 5th class, we will take up the theme of that movie, whether you've watched it or not. I can capsulize what the fun was about, and we can talk about it, because what we're talking about here are 2 questions. One, how do we compensate people? But secondly, what is justice? And we will spend the last 5th class talking about that. Any last minute questions? All right. Thank you very much. I will see you next week, and we will go to trial next week. Take care.